Assalamualaikum and a very good day, I bid sister. To begin, generally cognizance can be defined as to take notice of something and take it into consideration, particularly when judging, as according to Cambridge Dictionary. Simply put, when a court has knowledge or understanding of a matter, they are basically taking notice of an offence. The definition of cognizance, as according to the Black's Law Dictionary 10th edition, is a court trial and power to try and determine issue, taking judicial or authoritative notice and acknowledgement or admission of an alleged fact. In accordance with Section 1 to 8 of the Criminal Procedure Code, CPC, a magistrate may take cognizance of an offence in the defined situations. However, a magistrate must be aware of the limitations imposed under Section 1 to 9 until Section 1 to 2 of CPC before taking cognizance of an offence. Therefore, in this assignment, we will examine whether an accused is entitled to require the case to be tried by another magistrate when a magistrate takes cognizance of an offence upon his own knowledge or suspicion as being instructed to us.
Assalamualaikum and hi, I am Sayyidina Shakira binti Ahmad Jumali, matrix number 272612, and as of today, I will be explaining on the conditions and limitations requisite for initiations of proceedings. So first of all, with regards to the conditions for cognizance of an offence by the magistrate, which is governed by Section 128 of the Criminal Procedure Code. In this section, it states that a magistrate shall take cognizance of an offence by 4 conditions. The first one, by a complaint. The second one, by his own knowledge or suspicion that the offence has been committed. The third one, by a warrant issued by the public prosecutor requiring a magistrate to conduct an inquiry into the offence. And the fourth one is on any person brought before him in custody. So Section 1 to 8 subsection 2 further states that the accused has the right and is entitled to request to be tried by another magistrate for their case when the magistrate proclaims that an offence has to have been committed upon the knowledge or suspicions of the crime's commission. Further, with regards to Section 128 subsection 1 clause B, it states that a magistrate can take cognizance of an offence upon his knowledge or suspicion that the crime has been committed. This section actually telling us that a magistrate may act in accordance with this clause if he has the ground to believe that the crime has been committed, but is incapable to proceed in its ordinary sense owing to the absence of the complaint. So this power conferred to this clause is that the magistrate can take cognizance of an offence upon his belief or suspicion that the crime has been committed. Moving on to the jurisprudence on the cognizance concept. So actually, cognizance necessitates a magistrate in deciding whether or not to proceed or to progress ahead with the inquiry or trial of an offence which has been brought to his knowledge through one of the channels addressed under Section 128 of the Criminal Procedure Code. Moreover, cognizance functions as a preliminary stage to the inquiry or to the trial once a magistrate has taken the cognizance towards a crime. And it is within his discretion to pursue with the legal actions against any person unnamed or named, or he can do otherwise. So, based on the case of Muhammad Harul Azam bin Abdul Aziz against Tan Sri Tommy Thomas and also PP against Leonard, the principle that is to be highlighted is that the process of taking acknowledgements of an offence is an absolute discretion on the part of the presiding magistrates under this section. Moving on to the limitations for cognizance of an offence by the magistrate as laid out by Section 1 to 9 of the Criminal Procedure Code. So basically, this section laid out a prerequisite for the sanction to be initiated by a public prosecutor before a court can take cognizance of the offence. It sets the boundaries in which the court can take cognizance of an offence for such criminal offence. So based on subsection A1, it concerns on the offence punishable related to contempt of the legitimate authority of public servants, while subsection 1B concerns on the offence punishable for false evidence and offences as opposed to public justice, and also subsection 1C concerns on section 463 or offence that is punishable under section 471, 475 and also 476. The first related case is the case of Abdul Hamid against PP, where it emphasized between the difference on consent and sanction, and the second case is the case of Joginder Singh against PP, where it emphasized on where prior sanction is failed to be obtained for the offence which it was a precondition. The failure may only be treated as an irregularity and not considered cognizance to be void.
Assalamualaikum and a very good afternoon. I'm Sir. I'm Maudahani binti Zayuti, metric number 273278. So today I'm going to explain the procedures after the magistrate have taken cognizance. After the magistrate have taken cognizance, it can be implied that there is a legitimate grounds to assume that an offence has occurred in which section 133 until 136 shall apply. In the course of examining the complaint, the magistrate shall fulfill the elements listed down under section 133 subsection 1, and it was further outlined under subsection 1A and 1B that the public prosecutor may instruct the police to look into the complaint, and the magistrate shall not commence the inquiry if such instruction is made by the prosecutor. However, it is not applicable to the complaint of crime where summons is sought for in a summons action filed by a police worker or public worker acting in his authoritative position. As to the issue when shall the magistrate examine the complainant, we can see from PP against Mah Chuan Lim and others that the magistrate allowed to appear for an order for medical treatment after the accused attorney argued that the police had beaten him, and this is because it was held by the court that the order was lawful and the magistrate must first investigate the charge on oath, but there was no such complaint in this case. Besides, in Tan Ho Wat against PP, the court held that the magistrate takes cognizance of a crime when he intends to commence legal proceedings against the accused, and the magistrate is not advised to inquire about the complainant unless he takes cognizance of the offence. The main objectives of the examination are firstly to discover facts, to differentiate frivolous from substantive cases, to avoid detaining innocent civilians from being detained by the police, and lastly, to assist the magistrate in determining whether there is a basis for investigations and whether to proceed with the case. Section 134 talks about the postponement of issue of process, in which the magistrate may postpone the process if he has any doubts, and he may examine the matter by himself or instruct the police officer to inspect the complaint. If the magistrate prefers to look into the matter personally, he must provide a notice in writing to the public prosecutor at least 7 clear days prior to the date of the inquiry, and the public prosecutor may participate in such investigation made by the magistrate. However, Section 135 provides that if the magistrate feels that there are insufficient grounds to proceed, he may dismiss the complaint, and this section is only applicable to private persons and not the complaint by a public officer. So that's all from me. Thank you.
My name is Nurul Adini binti Abdul Razak with the number matrix of 244216. So for my part, I'll be explaining regarding the application and the analysis of section 128 under the CPC. So for this part, we'll be looking further into the concept of cognizance according to the section and also subsection 2. And then we'll see the implied requirement to be taken before taking cognizance over an offence. And lastly, we'll see the importance of understanding the application of cognizance. Understanding the concept of cognizance, we can see that in section 128 it is provided cognizance shall be commenced once the magistrate has the intention to put his judicial mind or the magistrate has the knowledge and suspicion over the offence. And this can be looked into the case of PP versus Lennon in 1960, whereby it was obligated for the magistrate to take cognizance over the case regardless how the complaint was submitted. Moving on to section 128 subclause 2, when a magistrate takes cognizance of an offence under this section, the accused has the right to request for another magistrate to try the case instead of the said magistrate. And the principle of cognizance of an offence and not the prosecution of an offender is applicable. The elements provided under section 128 has been fulfilled. This does not necessarily mean that there will be immediate legal action taken against the accused. It's just simply a matter of taking notice of the offence made by the magistrate himself. And this can be seen in the case of SK Sinha Chief Enforcement Officer versus Videocon International Limited in 2008, whereby it highlights the initial measure that the magistrate must take before commencing any legal action, as well as there is no particular legislation in governing the execution of a cognizance. The implied requirement to be taken before taking cognizance of an offence: firstly, the magistrate has to ensure that the offence can be taken into cognizance, whereby the offences falls under serious crime that is provided under the penal code. Secondly, the magistrate must first decide whether he wants to take cognizance or not. And since Section 128 must be read together with Section 133, once cognizance has been established, then the procedure outlined in the following section can be commenced. The importance of taking cognizance is it acted as a safeguard for the accused from suffering any judicial injury, as well as acted as an initial checking mechanism for the magistrate if there is a prima facie case to be tried. So in simpler meaning, taking cognizance over an offence is simply discretionary on the magistrate's behalf, as well as it guarantees the accused's right on requesting to change the magistrate if he wishes to.
In conclusion, based on our discussion, an accused is entitled to require the case to be tried by another magistrate when a magistrate takes cognizance of an offence upon his knowledge or suspicion by virtue of Section 128 subsection 2 of the Criminal Procedure Code. It is pursuant to Section 128 subsection 1 subsection B, which allow the magistrate to take cognizance of an offence when it has come to this knowledge that such offence has been committed. Furthermore, Section 128 also outlined other situation in which a magistrate may take cognizance of an offence, but they are still subjected to the limitations imposed under Section 129 until Section 132 of the Code before taking cognizance of an offence. So that's all from us. Thank you.